Good afternoon, everyone. Thank you for joining in. A humble request to keep yourself on mute and your video switched off. Please note that we would also be recording this session. I'm Pinky Das, and it gives me immense pleasure to welcome you all to the webinar series hosted by Third Sector Partners in collaboration with our partner organizations, Go Barefoot, a membership-based interactive web portal dedicated for the social sector, and Catalyst, our social initiative which prepares young women pursuing professional education for leadership roles, thereby creating a wider talent pool for India and helping bridge the gender divide. Today, we will talk about the most recent change implemented by the Government of India that impacts the existence and operations of the non-profit organizations. As we all know that the FCRA Amendment Act came into force from September 29th, 2020, and we all are trying to understand and decode the nuances involved. Over the next 50 minutes, we will discuss the various implications of this amendment with our esteemed panelists, who I will introduce shortly. We have reserved the last 15 minutes to address questions from the audience. Please direct all your questions to the host in the chat box. You may specify the name of the panel member to whom you wish to address the question. Without further ado, ladies and gentlemen, let me introduce you all to our panel members. We are privileged to have with us today Mr. Naushir Dadrawala. Naushir is the Chief Executive Officer of Center for Advancement of Philanthropy, through which he has been offering compliance-related advisory to nonprofits and corporate social initiatives. His career spans over 35 years in the nonprofit sector, working with a diverse range of organizations from large established national and global organizations to corporate and family grant makers to startups. Drawing upon 3 decades of hands-on experience and practical insights, Naushir's main role at CAP involves simplifying the confusing and complex maze of old but ever-changing new laws. Naushir's legal expertise in the sector is widely recognized, as is his deep understanding of compliance within philanthropy. His current international affiliation includes serving as member on the advisory board of the International Center for Not-for-Profit Law. Earlier, he was on the board of Worldwide Initiatives for Grantmaker Support and also on the Asia Pacific Philanthropy Consortium. Next on our panel is Mr. Vineet Rishi. Vineet currently holds the positions of Director of Administration, Foundation Secretary, and Director of the India Program at Oak Foundation. Vineet is based in Geneva, Switzerland, and leads the teams responsible for finance, grants administration, information technology, human resources, and organizational development, and oversees real estate and facilities. He also manages the India program, which focuses on supporting acutely marginalized populations living in the tea gardens. Prior to joining the foundation, he was the Chief Financial Officer at Logispring, a venture capital managed the tax and treasury function for Europe, Middle East, and Africa, and Asia Pacific Iomega Corporation, a New York Stock Exchange listed company, and was an associate partner with Arthur Andersen. Vineet serves as the governing council of the European Foundation Center as a member of the board of Partners for a New Economy, the Tanya's Dream Initiative, and chairs the Operations Professionals Network. Next, we have Dr. Manoj Fogla. Dr. Fogla is an advocate by profession. He is the founder of the law firm Saga Law LLP. He is a fellow member of the Institute of Chartered Accountants of India since 1990 and holds a master's degree in philosophy. He has completed his PhD from Utkal University on accountability standards for voluntary organizations. He is a legal advisor and consultant to many national and international NGOs and corporates. Dr. Fogla has authored several best-selling books like The Comprehensive Commentaries on Taxation of Trust and NGOs published by Taxman Publications, Handbook on CSR for Corporates and NPOs, Commentaries on FCRA and Lokpal, and Legal and Financial Handbook for Voluntary Organizations. He is on the board of management of many reputed institutions, including Xavier's University, Bhubaneswar, and ASBM University. And our fourth panel member is Mr. Biraj Patnaik. Biraj is the Executive Director of National Foundation of India. Prior to joining NFI, he was the South Asia Director of Amnesty International. He was formerly the Principal Advisor to the Commissioners of the Indian Supreme Court in the landmark Right to Food case for close to a decade. A well-known human rights activist, he has been part of many national and global campaigns, including the Right to Food campaign in India. Biraj co-founded the Mitten Community Health Worker Program that trained and deployed 70,000 health workers in Chhattisgarh. Thank you, panel members, for accepting our invitation and joining us today. The journey of FCRA Act goes back to 1976. It has been 44 years and we have witnessed multiple changes and amendments till date. Ever since the recent amendments came into force, we have seen instability and curiosity in the minds of the people about the whole change and the nuances involved. To understand this in detail, my first question is to you, Biraj. What, according to you, was the larger purpose of the government to amend the FCRA law? And are there laws similar to FCRA in other countries? Is there a trend there, or is India an isolated example?
So let me start with the second part of the question. What is the global trend? Now, firstly, if you look at the intent of the Foreign Contribution Regulation Act, this intent, which was to curb foreign interference in elections, which was the original intent of the Act, this is an emergency era legislation, is in itself unexceptionable. Most countries have some form of law or the other which prohibits political parties from being funded from abroad. And even very mature democracies do not want foreign interference in elections for obvious reasons, because it impacts the sovereign nature of a country. Look at the last elections in the US, where there were huge allegations of Russian interference 4 years ago. Or look at the in the UK, when you had the Brexit referendum, there were allegations of foreign. So this anxiety exists in mature democracies as much as it does in newer democracies like India. Unfortunately for India and many other countries, the intent of the law, which is to curb political interference in elections, is now completely focused on civil society. It's become a law that is being increasingly used across the world, not just in India, but across the world. Authoritarian regimes are using this to curb any form of civil society action, to limit civic space, to ensure that they are able to, curb dissent in their societies, and keep governments trying to keep civil society under control and under check. In India, I think there was a lot of anxiety in the government because they represent a certain ideological stream where a large section, particularly of the left liberals, are not falling in line. The anti-CA and RC protest was literally the straw that broke the camel's back. The opposition that they are facing in international fora due to the presence of organizations like Amnesty in India was another factor. So I think a number of these factors came together for the government to say that we are going to tighten this legislation through amendments. But like all bad laws, which are bad not just in intent, but worse in application, we are now throwing the baby with the bathwater. So it's come a full circle. In terms of where we are, let's say South Asia, I think Afghanistan, Sri Lanka and Nepal have the most progressive laws. I mean, I lived in Colombo and ran an international operation for 4 years. There are close to zero restrictions. There's nothing anywhere near an FCRA in Sri Lanka because foreign money coming in is not regulated by the state. The same with Nepal. There are very few restrictions on foreign money other than the outflow of capital once it comes to the country. Afghanistan is perhaps the best in terms of foreign funding, even though in security and other aspects, it's not the best place to do business. India, Pakistan, and Bangladesh, in varying degrees, have been the pioneers in repressing civil society. And unfortunately, India has taken a lead. So if you look at the digital security laws, they immediately get replicated in Pakistan. They immediately get replicated in Bangladesh. Same with the FCRA. Both countries are considering. And the new amendments, what has happened is, after they were released, even Sri Lanka, which has zero control so far on foreign money coming in, is now saying, hang on, if India can do it, we can do it too. So a country like India, which is the beacon for constitutional morality and rule of law in the subcontinent, and was a champion of this for many decades, is now increasingly being looked upon by authoritarian regimes here and elsewhere as a harbinger of laws that can be used to curb civic action, limit civic space, and prevent civil society from doing what it's meant to do, which also includes rights-based work, advocacy, and championing the cause of the dispossessed.
Thank you for the insights, Biraj. Considering that most organizations were already grappling with the COVID scenario, this amendment too came in as a surprise for us. Moving to the next. Since Oak Foundation is a grant-making organization, Vineet, we would like to hear from you, how are some of the grantee organizations reacting to this change?
Thank you, Pinky. Good afternoon, everyone. So from Oak's perspective, we're funding a number of organizations in India to do advocacy and rights-based work, but we're also funding a lot of work around social change and social upliftment. And our focus in the Sundarbans and the tea estates are some examples of the kind of work we're doing. We're also funding think tanks in India that are working on climate-related issues, and particularly in working with the government on climate-related issues. And so we're a little bit taken aback by this law. I mean, as you can imagine, we're not an operating foundation, we're a grant-making foundation, which implies that we build partnerships with organizations working on the ground in India. And our intent is to reach grassroots organizations that can work with communities and uplift those communities and give voice to those communities. In order to do that, we fund, let's say, a largish organization that will then work in the Sundarbans with small community-based organizations, and that will reach out into the villages and the rural areas and try to mobilize society to advocate for their own priorities. And the only way we can do that is, I mean, we're not equipped to go out into the ground at that level. And so the only way we can do that is to give grants to organizations that will then work with partners. At this point in time, there's a little bit of panic amongst these organizations because of the restrictions on re-granting or on working with others and how you can deploy funds. And also panic around this 20% regulation on administrative costs and how that is to be interpreted. So our grantees are scrambling to figure out how to continue to operate and how they can disperse the funds and carry on with the projects that were already underway.
Thank you, Vineet. Talking about administrative costs, we do have kept one section to cover those questions as well. Thank you so much, Vineet. Moving forward to Noshir, I would like to pose my next question to you. There is a lot of ambiguity in terms of the existing funds that had come in for the ongoing projects for this amendment. Could you throw some light on this?
Yeah, sure. Thank you, Pinky. So first of all, I think this came virtually as a surgical strike on the voluntary sector when we were midstream. To initiate something like this in the month of September means it was virtually right in the center of the fiscal year that is observed in India from 1st April to 31st March. Till 20th of September, nobody had even a clue that something like this would happen. It was only around afternoon time that some of us who are on various groups, including Dr. Fogla and others, we started talking about, hey, do you know something is going to happen in Parliament today? And within 9 days, this becomes law. Bill was presented in Parliament on 20th and on 29th it is law. So now monies that have already come in to intermediaries, and the intermediaries are the worst hit in this regard. Most of them get their monies in quarterly tranches or get them in half-yearly tranches. So monies are already here and waiting to be distributed. And I'm speaking to these kind of intermediaries every single day. And one had hoped that when the rules come out, maybe there would be some kind of relaxation offered, as relaxation was indeed offered with opening the State Bank of India bank account, where we've been given a little bit of a breather that, all right, I mean, between now and 31st of March, open your bank account with State Bank, but till then operate your existing account. No need to close this account down. You can receive money in your existing account, use from it. And one had hoped that this kind of a situation would have been allowed for intermediary series as well, that if monies have come in, but there's nothing, this complete silence under the rules. What does the silence mean? The silence means that effective 29th of September, you cannot be making any sub-grants or grants at all. If you do that, it's a violation of FCRA. And what's worse, it's not even a compoundable violation. This is not among the compoundable offenses where you pay a certain penalty and move on. Of course, that itself is a tedious process. But it's not even compoundable. So if it is not compoundable, what can happen? Based on a summary inquiry, they could suspend you. And earlier they could suspend you for 180 days. Now you can be in suspension for 360 days. That means for literally a year, your bank account would be frozen. And after 1 year or 360 days, one wouldn't know what happens. They might say it's a very serious violation, and all the balance which is lying in your amount will be vested in a competent government authority, including all FCRA assets, etc. So you realize the seriousness of this change that has been brought about without any sensitivity to the needs of the sector, especially at a time like COVID. So what are the options really that we have? There is one option is that the intermediary probably returns the money back to the donor overseas. And historically that has been done in the past, where usually grant contracts come with the rider that any unspent money will be returned to the donor. This is a situation, but government has not given us any clarity whether this money can be sent back to the donor. One is only assuming you can do that, or the intermediary conducts these processes or implements the projects and programs on its own by hiring staff and consultants. There are lots of people who are talking, can we now work with the NGOs on contract basis? I'm not too keen on that, because if you have been traditionally a grant maker and are now going into a contract mode with them, it's anyone's guess that you have just tried to camouflage a grant into a service agreement, and it can raise various complications both for the giver and the recipients. So I think the best way forward is probably return of the money to the donor, or implementing agency doing this on its own. I'll just stop here.
I'm sure this clarifies most of our doubts. Thank you, Naushir. Moving on to the next question. We all have read about the changes in terms of renewal of the FCRA registration, but we may not be aware of the implications at a macro level. On this note, Dr. Fogla, I would like you to take up this question and help us understand the implications of the Act on renewal of the FCRA registration.
To my understanding, the change in the renewal law is probably one of the most underestimated change in terms of the implication it could have, both at the micro as well as the macro level. If you try to understand, a renewal is normally a status quo provision. Renewal means that you continue as it is if you are compliant otherwise. Therefore, even in 2016, when the renewals were happened, it was virtually automatic renewal. All the organizations which were otherwise compliant, they were filing their returns, they had a right to be renewed. So that was the provision, and it is consistent with all other laws. We have a renewal provision under the income tax law as well, which the change has happened simultaneously. In the budget last year, the income tax registration, that is the 12A and 1023 registration, they also have been aligned with FCRA law, and all registrations are now for 5 years. But for FCRA, the problem is that there were three major changes, three provisions. One should note it down. When the renewal provision came, this amended law says that now onward renewal provision will be subject to all those processes which are being done at the time of prior permission and registration. That is section 12(4) of the FCRA Act. That means you will be subjected as a new organization every 5 years, and you will be subject to all those inquiry at the discretion. But there is a fundamental difference. One has to understand that when an organization applies for the first time, the authorities are required to do a due diligence because they don't know the organization. At the end of the 5 year, the organization is already being assessed, and on quarterly basis, the organization is filing returns, quarterly returns, annual returns, and various kinds. Each and every changes, for instance, a change in board member and various other changes are subject to FC approval. So in such circumstances, on one hand, it has been put that a renewal will be on par a registration process, which will empower the authorities to block the renewal even if there are certain non-compliances. You must understand, and in the normal course, you cannot cancel a registration if there are some procedural non-compliances, but you can hold a renewal. So it will be easier to hold a renewal, which is basically a deemed cancellation. But to cancel an organization, you have to go through a lot of processes, and the FCRA department has to have evidences in position to initiate those inquiries. Those would not be necessary at the time of renewal. So that is where there is too much of discretion at the hands of the authority, which I think it should be is a matter of concern. The second part, which has come in the rules now, the rules say that if you don't apply for renewal, or if your renewal is not granted, it will be treated as a deemed cancellation and your assets will vest with the authority. That, to my understanding, is an infringement of fundamental rights because it is a private money. Without recording or establishing non-compliance, how could the assets be vested in a prescribed authority? Because in all laws, there has to be a violation of the law and a cancellation proceeding which has to be effected, then only this kind of coercive measures could be taken. So renewal in that sense is a very law which we should be concerned about, and I don't know, we have to see how these authorities use this discretion. In times to come, we will be knowing how it is being implemented.
Good to know the points that we need to keep in mind, Dr. Fugla. Thank you so much for sharing with us. Coming back to you, Biraj. According to you, does the amendment mean barrier to free speech, advocacy, and political activity?
So I think on political activity, let's be very clear that NGOs do not and have rarely, if ever, and I'm saying rarely, if ever, I would have said 100% if it was a couple of years back, when some of us had put a right to information application to ask the Ministry of Home Affairs, please tell us how many NGOs have you found who were indulging in what you have called as political action. And the response of the Home Ministry was none. In 44 years, they have not found an NGO which they have accused by their own yardstick of political action. Number one. Number two, the Supreme Court recently, as you know, a few months ago in March, gave an order which wrote down what constitutes political activity. Because as you know that under Section 5(1) of the FCRA Act, political activity could also be defined in terms of something that was not by a political party. So any protest, any dharna, any agitation, rally, hartal, any public event you held could arbitrarily be called by the Home Ministry, as the Ministry of Home Affairs, as a political action. And the Supreme Court wrote down that to say that, look, any expression of dissent cannot be labeled as political action, because organizations in the civic space have the right to express themselves through legitimate means that are available to everybody else in a democracy, and you cannot pinpoint that as political action. They did not write down the law, the act. What they did write down was the rules, which meant that if you did any party political activity, suppose you were an NGO and you were part of a political party or did rallying in a constituency for a particular election, something very obviously linked to party politics and electoral politics, then the state has the right to take away your FCRA. So that was a clarification given by the court. Now, in terms of advocacy and freedom of speech, I think that is where it will hurt the most. Because if you look at this 20% restriction, what does it really mean? Because a lot of people tell me, if you talk to a common person, their understanding on this is slightly different than what NGOs hold. They would say, what is wrong if only 20% of the money was spent on yourselves and 80% is spent on a project? it doesn't sound very very drastic. Shouldn't the majority of the money be spent on the project in any case? That is where but what the nuance there is, that what is defined as administrative expense is so tight that any campaigning you do, any advocacy you do, any public event that you do would all constitute would be construed in accounting terms as administrative expense. And therefore, it restricts the ability of these kinds of organizations to use foreign money. So therefore, the intent is quite clear. You cannot do research, and in research, only the salary of a field researcher can be booked as a program expenditure. But a large research program or that of a think tank would get severely impacted, because it would now be left to the interpretation of the authorities on whether this is admin expenditure or not. And that's where the curbing of the freedom of speech happens, because you are curtailing certain kind of organizations. If you're a service delivery organization, if you're building toilets or schools or health facilities, 20% doesn't matter, because your expenditure buckets are very large, and you'd always have material cost, labor cost, and so on, which are evidently program costs. So it doesn't matter. Therefore, what the intent of this amendment is to prevent civil society from campaigning, from advocacy, from research, from critiquing, or from any kind of action which the state would deem as not in the service delivery frame. So it fixes the sector into service providers and subcontractors, either for the government or for projects that the government wants to implement. So in that sense, I would say what Noshir and Dr. Fogla and Vineet have been saying, that this is truly a game-changing amendment, and much more than the right to the freedom of speech, it is a complete assault on the freedom of association, because Article 19 of our Constitution guarantees me to be associated with you. If I'm taking money from, let's say, my organization takes money from Vineet's organization, and we work with Noshir's organization, the relationship is not just financial. It is a relationship where we have come together because, say, we want to address climate change in India. It's an association where the fiduciary element is just one part. Now, the moment you restrict my ability to take funds from, say, Oak Foundation and give it to Noshir's foundation or to Dr. Fogla, what you're doing is you are limiting my ability to associate with each other. And I think that is a violation, because you're fundamentally saying that only one kind of money you cannot re-grant. You can re-grant Indian money, you can re-grant money from Indian philanthropists, you can re-grant money from donations you can collect from the Indian public, but you cannot re-grant money from foreign sources. So by its very nature, it is discriminatory. And therefore, what it needs really is a very robust constitutional challenge in the times to come.
Thank you, Biraj, for sharing such a candid perspective with us. Moving forward, we all know that the PM CARES Fund has been registered as a public charitable trust in March 2020, but we may not be aware why it has received an exemption from the provisions of the Act. Noshir, would you help us understand why?
A very loaded question and a not so loaded answer. First of all, under the Act itself, that is the FCRA Act, there is Section 15, which gives powers to the Ministry, 50, which gives powers to the Ministry of Home Affairs to exempt certain types of organizations. Even if you look at an order that was passed this calendar year itself, on 30th of January 2020, MHA passed an order that all organizations constituted or established by or under a central act or a state act or by any administrative or executive order of the central government or any state government and wholly owned by the respective government and required to have their accounts compulsorily audited by the Comptroller Auditor General, that is CAG, or any agency of that sort is exempt. Now, this is not a sweeping kind of a condition under which you can be exempt. It must be state-owned, centrally owned, accounts must be audited by CAG, etc., which we don't find in this case. Even much before, if you will see that there are certain government funds that have been exempted under FCRA. A classic example is the order that was passed on 16th of June 2016, where Swachh Bharat Kosh, which is registered under the Societies Act of 1860, has been exempt under FCRA. There's a order to that effect, which is for anyone to see. It's in public domain. But what loophole has been exploited under Section 50 by the Ministry of Home Affairs, and it's a loophole, is that the Section 50 says, if in the opinion it is found necessary or expedient in the interest of general public to do so. So therefore, Ministry of Home Affairs has, in its own opinion, thought that it is necessary or expedient in the interest of general public. And what was the interest of the general public? The pandemic. It was a crisis situation, you know, and we need this money so desperately. Let's exempt PM CARES from this. Not for a moment I'm holding up a candle to this, that this is something good, but this is a loophole under law that has been exploited. Why I personally feel that a PM CARES fund should not be exempted is because it is not set up through a central or a state act. It is a public charitable trust registered under the Indian Registration Act in New Delhi. To date, its trust deed is not in public domain. We don't know what it contains. What are the objects? We have some idea about who are the trustees. It's a select handful of trustees, but we don't know what the objects are, how the trust is to be governed, not known. And therefore, the second step was certain public spirited individuals try to file RTI application, the right to information. We need to know more. And what was the answer given? That the PM CARES fund is not a public authority as defined under the RTI Act. To be a public authority, you must be substantially funded by government. PM CARES funds takes the view that we are not substantially funded by any government authority, and therefore we are exempt under RTI. And what's worse, big deal is made out. You know, we are not audited by CAG. We have an independent auditor who looks at us. For heaven's sake, the 3.3 NGO, 3.3 million NGOs that are talked about are also audited by quote unquote independent auditors. I rest my case.
Well, that's very interesting to know. Thank you so much, Naushir. My next question is to you, Dr. Fogla. How does the amendment change the role of a public servant on the governing board? Why does the presence of a public servant on the board stop organizations from getting FCRA receipts?
No, we have to understand there is a lot of confusion and misunderstanding regarding this amendment pertaining to public servant. One, in 1976, when the FCRA Act came, it applied only to associations. So primarily it was targeted towards NGOs or charitable institutions. But in 2010, the FCRA Act was broadened and virtually everybody was brought into it, and individuals were also brought. So any individual is also under FCRA, along with charitable institutions, Section 8 company, HUF, and other institutions. So therefore, the prohibition which has come under regarding public servants is the prohibition which is already there. There was a Section 3 in which a category of prohibited persons is provided inside the Act. It includes government servants, it includes organization engaged in say media activity, audio visual, it includes. So there this public servant has also been added. So now in their personal capacity, they fall in the prohibited category. So they cannot touch foreign contribution. But as far as being on the board of a organization is concerned, under the civil law, under the FCRA law, under the income tax law, no coercive provisions exist pertaining to the category of the person on the board. But normally it would be difficult for a government servant to be on the board because the government servants are otherwise also bound by their service rules. So if the service rules provides and if the government servant is allowed, then even today, even after this amendment also, a government servant, including a public servant, can be on the board of charities. There is no bar even today. But a public servant need not necessarily be a government servant. That is the catch in this amendment, because there were some FCRA cases where it was asked that why certain individuals who hold which are otherwise constitutional duties, it could be an election duty, it could be a job of a government advocate or a public prosecutor. There could be various positions which are allied to government duties, but they are not government servants. So that was, government perceived it as a loophole in the act, that that particular category was left out. So they have plugged that. It is a much talked about case in the Supreme Court in which this question was raised. I am not going into the details. So they have plugged that category, government servant and any other person, whether a private person or a public person, if they are engaged in any kind of public duties, they also fall under the prohibited category. Subject to their service rules, even today they can be on the board of charitable organizations, including FCRA organizations.
Interesting to know this. Thank you, Dr. Pugla. A gentle reminder to the audience to direct your questions to the chat box. Moving to the next question, Vineet, can you help us understand how the amendment will impact the future engagements of international donors in India?
So Pinky, as Biraj said earlier, what we're seeing is a trend of restrictive practices across the world, not just in India. And this challenge exists for donors that are working internationally, any of these countries, whether it be China, whether it be in African countries, in Central and Eastern European countries. This challenge exists and is growing. And we view it as something that's linked with the rise in populism and the rise in nationalism. And it is reducing the scope for international donors to work in any country. Now, just to be clear, international donors are not nefariously working in any country as independent agents. They're working with Indian NGOs and with people that grew up in India, live in India, and are advocating for changes in their own nation. So it's not some external agenda that's being imposed on India. It really is funding that's coming into these countries to support civil society. And the civil society, historically or traditionally in many countries, has not received local philanthropic funding. That's because the giving patterns were different. People gave through religious organizations. The state played a bigger role. And this was true in Europe as well. And then gradually over time, we've seen a shift and a change where people have become more active and demanding of their rights and expecting that the state will fulfill the rights and allow people to determine their future. And so there's been money that's available from private sources in order to fund those kinds of movements of civil society. So what we see happening, because we work with a number of foundations in partnership, we don't work alone, and we work with local actors in each of the countries in which we work in. And what we see is a consultation process within international donors that are now considering how they may react to a global trend of shrinking space for civil society and what they can do about that. You know, the traditional governments or the traditional consensus around human rights and liberty has been challenged a little bit with these movements of populism and nationalism. And there is a pushback that's coming from civil society. So we can only encourage civil society to respond and react. As far as Oak Foundation goes, we're waiting to see how the rules will be formulated. We poured money into India during this COVID crisis when the migrants were moving and when people were suffering in March and April. And that was encouraged by the government. Of course, the government wanted resources to come into the country. And I think there's a recognition that a very positive role was played by philanthropy and civil society in helping alleviate some of the ill effects of the pandemic. And so we're hoping that the government will recognize that there's a role and will formulate its rules in a way that gives space and allows space for us to continue to work in India, but that remains to be seen. There is some concern that a lot of the local money, CSR money, has gone into the PM Cares Fund, and so there's less money available to civil society because it's all being sucked into one particular fund or trust that's controlled by the government, which leaves very little space available for the rest.
Well, thank you so much for sharing your insights, Vineet. We do understand because international donors have always played a very critical role in supporting the development sector work in India. We all know that the administrative cost has been capped at 20% from 50%. We have received a lot of questions from the audience on this subject before the webinar. To get some more clarification on this, Naushir, I would like you to address my next question. What all constitutes the administrative cost? Also, in what cases can the NGO take prior approval from the central government to exceed the 20% administrative cost?
Yeah, thank you. A bigger question that even the government of India has not answered is this cap of 20% applicable from 29th of September or from 1st of April 2020? If one looks at the new form FC4, it is indicative that it is already applicable for the financial year 2021. This is my interpretation, and which is very worrisome because, as I said earlier, this law was thrust upon us when we were midway in the financial year. We are talking about the last week of September. Organizations, based on the understanding that we have allowed up to 50%, have already spent in September 25%. Are they already in fault? And they are spending sleepless nights over it. And for which I told them that, look, listen, I mean, what's the worst case scenario? They are not going to deregister you. It will be a compoundable offense, and which means you will have to pay a certain penalty, which is rather high. But you paid and you'll still be able to move on. Your accounts won't be frozen because of that, or you won't get deregistered. But it's a question we thought the rules would clarify that, all right, this 20% cap is effective. Preferably, it should have been from the next fiscal year. But when one looks at the new FC4, it's already there among the disclosures that I have not spent more than 20%. And this is what you're going to report for the fiscal year 2021, which means you're looking at the entire financial. And this is of a bigger worry to me. You had this question, can we take prior permission for that? Yes, the act is very clear that with the permission of the Ministry of Home Affairs, one can spend more than earlier 50%, now it is 20%. But what is the procedure for that? Is there any provision under the rules for that? The answer is no. Is there an FC form that one can fill up and say, hey, listen, this is the reason why I got to do this? What is the mode of communication? Should you send them letters by speed post or registered post? They have always claimed that we don't accept any hard copies anymore. They just lie unopened envelopes in our office. So should we send emails to them? If we send emails to them, will they respond to it? Will they take cognizance of it? This remains very, very ambiguous. But I can only provide clarity in terms of what is admin cost. But I have no clarity. I would only work on the basis that probably this 20% restriction is effective for the full financial year 2021, as is indicative under under the new form FC4. But what is admin cost? That's not hard to seek. If anyone opens the foreign contribution regulation rules, and that's easily downloadable from FCRA online, and look up rule number 5, it lays down what are admin costs. And of key concern is salaries, wages, travel expenses, or remuneration realized by members of the executive committee or council. That means if these are payments that you're making to your board members, then those are admin costs. And the second one is more loaded. All expenses towards hiring of personnel for the management of the activities of the person and salaries, wages of any kind of remuneration paid, including cost of travel to such personnel. So any management related costs, which means somebody who is at your front office, somebody doing clerical work, your accountant, somebody who answers your telephone, all these are management costs. And these would definitely be admin costs. And admin costs also includes all your utility bills, your telephone, electricity, that comes under subclause 3 of Rule 5, cost of accounting, legal fees, rent of premises. It's all very clear under Rule 5. There are only 2 exempting proviso. The first proviso says, provided that the expenditure incurred on salaries or remuneration of personnel engaged in training or for collection or analysis of field data of an association primarily engaged in research or training shall not be counted towards admin costs. So this is restricted to organizations that are involved in research. So it's very restrictive there. The second one is less restrictive, and it comes, which is the second proviso, provided further that the expenses incurred directly in furtherance of the stated objectives of the welfare-oriented organization. Now, I want to lay emphasis on this term, welfare-oriented organization. Who is a welfare-oriented organization? Not defined anywhere under law. You can only derive inference that somebody who's a think tank is probably not welfare-oriented. Maybe someone who's into advocacy work is not welfare. Anyone who government deems is anti-national, because that's a popular word now, is not a welfare organization. So, and shall be excluded from administrative expenses, such as salaries to doctors of a hospital, salaries to teachers of a school. Now, this word such as is an indicative term. So, if you are an organization working in livelihoods or skill building, they would be also a form of teachers. So any salary that you pay to somebody who is helping with skill building, livelihood, all that kind of expenditure can be booked as a project or a program expenditure and not that. So in a nutshell, if I were to put it, all management salaries and remunerations on your activities would be admin, but anything that is directly implemented for the project and salaries that you pay to such persons, such as, the term uses such as, doctors, teachers, if you have therefore paramedics, then even salaries to paramedics or midwives, etc. If you're paying any remuneration to them, that would count as the program cost. Thank you.
Thank you, Naushir, for bringing clarity in our understanding. Biraj, my follow-up question is to you. This cap on administrative expenses may hinder efforts on internal capacity building, attracting relevant talent, and focus on innovation for nonprofits. This in turn may impact productivity of smaller nonprofits as well. How do you think such organizations would go?
So I think more than the smaller organizations, because remember that the smaller organizations in India, if you have a turnover of say less than 50 lakhs a year, which would be the vast majority of small organizations, they would in any case be complying with this law and in any case have admin expenses that are lower. So if you look at the data that the Home Ministry has today, and you look at the last 3 years, and you look at all the organizations who have filed their FC returns, less than 10% of organizations are those which say that they have a cap more than 21% or 20%. A vast majority of organizations already follow this. That's because salaries are low. You're working in small towns or rural areas. The cost of getting people is low because you're not recruiting on a massive scale, and you're certainly not hiring third sector partners to get your senior executives on board. So your costs are modest. The impact will be on intermediary organizations, it will be on mid-size organizations, and it will be on large organizations. Because a large organization or a mid-size organization will have, say, a public engagement function that is pure admin. It will have a fundraising function that is pure admin. So the restrictive growth that you will see in the sector is to make larger organizations either disappear because they can't cope with the law or shrink them, and thereby impact smaller organizations because you reduce the ability of small organizations to grow, and you reduce the ability of large organizations to help smaller organizations. So the impact on smaller organizations will be indirect. The impact on larger organizations will be much more. Now, in terms of what these organizations can do, the non-profit sector in India will morph in part into the for-profit sector. Basically, what you're doing is you're pushing out people and encouraging them to either go back to corporate careers or make a corporate career out of NGOs by registering for-profit entities, which would be outside the ambit of these laws and which would be outside the ambit of FCRA and which would only do service contracts, pay up the 18% GST, and happy days. And therefore, it would change the very nature of the sector. Because if you look at the amount of money that's coming into India while it's a tiny proportion of our entire GDP, it's very, very significant. It's not a joke. If it's already reduced by 60%, you can easily say that one can predict, and Noshir and Manoj can correct me if I'm wrong, that it would go down by another 50% in another 2 years, given this, because why would a Oak Foundation continue to invest in India if they are constantly under the threat of violating the regulatory or being in violation of the law or having problems with the regulatory environment here? They would say, look, our money is better served in Indonesia or Vietnam or other countries which have ease of doing business, better for NGOs. So I think that is going to be really the hit. You're not going to attract the right kind of talent. You will not be able to remunerate your people adequately. There's a worldwide acknowledgement across the globe, even in the United States, in Europe, that the true cost of running third sector organizations or not-for-profits is much higher than, because you have people playing multiple roles in a size of the organization that in the corporate sector and in the NGO sector. The corporate sector would have many more people on senior management looking at different verticals. Here you have chief executives playing 4 roles. So instead of, and there's a whole movement called Pay What It Takes to address this globally, we have taken 4 steps backwards, where we are saying that the state has no problem with the nature of your expenditure, but we will question you on the destination of the expenditure. So it is what some friends call the license permit Raj for NGOs coming back all over again. So you are going back to the 1980s for the NGOs while you are trying to take corporations into the 21st century by decriminalizing provisions in company law, in FEMA, and making them more and more offenses compoundable rather than criminalize it. And on the other hand, you have the FCRA become far more punitive. And I think that's why I would repeat again that even while it's not acknowledged as widely or understood as widely, these changes have the ability to completely transform the nature and character of civil society in India, and it is a change for the worse.
Thank you, Biraj. The next question again is to you. Smaller NGOs that function in the remote areas of the country have been codependent on bigger NGOs having access to foreign funds. What, according to you, are some of the solutions that they can adopt to sustain themselves?
So I think there are 2 ways of looking at this problem, both from the supply and the demand side. I think what would happen is that there is a challenge for international donors who are abroad now, because they can no longer use intermediary organizations in India. And I think, therefore, this is a problem that has to be fixed between intermediary organizations and international donors. And there are many ways to fix it, because any law that you have gives you enough flexibility or ability to adapt to repressive circumstances, and people have always done that. For instance, you may have intermediary organizations which now which will open not-for-profit entities abroad, where those entities can now continue re-granting. That's one possibility. Because I don't think that the challenge of reaching out to global capital or global funds can be left to the smaller organizations. It is the duty of the intermediary organizations and the duty of international donors to come to their rescue, to ensure that work does not get affected. And I think they would have far greater ability to do it than the smaller organizations. Because if you look at NFI, 66% of our work last year was re-granting. and it was re-granting through FCRA, something that we cannot do now, which means that 66% of the work of my organization, which means that a large amount of funds that were going to organizations on the ground, about 60 to 70 organizations on the ground, which were being supported, we will be unable to support. Our donors will be unable to fund us to support these organizations. Now, to expect those organizations to be able to directly raise the money with the donor is going to be very difficult. So an organization like NFI will have to change its nature, character, intent, ways of working to ensure that their partners do not suffer, that our partners on the ground have the capacity or the ability, or we continue playing some kind of a role to link them directly with the donors. And that's exactly how we are now restructuring ourselves to meet this challenge. And of course, we'll have to now operate through a much wider ecosystem of institutions than we have. The era of the self-contained entity in India, which was formed with good intent by some of the finest citizens of the country coming together like NFI was back in the day, that era is over. It cannot be a self-contained institutional framework. Institutions will have to morph themselves into a network or into some kind of an ecosystem of for-profit, not for-profit, hybrid entities based out of different geographies with corpuses outside of India to be able to do business in India. So it just makes it that much harder for us to operate than it did in the past.
Well, thank you, Biraj, for sharing your suggestions with us. I'm sure these pointers will also help many of the grantee organizations. Moving on to the next question. Vineet, I would like you to share your views with us regarding what is the way ahead for CSR donors who can only support FCRA registered nonprofits?
So I'll pick up on what Noshir and Biraj have just said. So we are engaged in an exercise to define and identify what would be considered, for example, administrative expenses. And Noshir is very clear in his mind, but if you go and consult with different experts on the subject, you get different answers. It's not like you get one standardized answer. And so the fear is that the government will also interpret this depending on the particular situation of the organization and whether they like what you're doing or they don't like what you're doing. So they will consider each case depending on their particular whim, I'm tempted to say, but their particular bent of mind at the time. So what we're doing is we're researching, along with experts in India, how we might define some of these things, and then we want to hold capacity building sessions for our partners on the ground in India so that they understand what the definitions are and can adapt what they're doing. We're also looking to provide fundraising support to our partners so that they could hopefully get more local funding, which will allow them to meet their administrative expenses and so use foreign funding more flexibly for the programmatic work. And then finally, we're looking at some of the options that Biraj was laying out of how we can use intermediaries outside of India to grant into India. But of course, each of these activities leads to greater cost and requires more time and energy on the part of our staff. And since we're limited in the number of staff we have, it's a challenge for us. So whereas, even if you engage with an intermediary now outside of India and you're saying that you want to grant into India, if suddenly you're having to make 50 grants, whereas you were making 10 before, the administrative process or the administrative burden of doing that has been multiplied by 5. And so that is the challenge we face, and we're going to be looking at what's feasible to do. There's some consideration to seeing whether the government would be open to discussion, and would they be willing to be more flexible in some areas and perhaps formulate rules that might be more accommodating. But we're not holding out too much hope at this stage, given what we've seen so far in terms of the lack of engagement on the part of the government before formulating these rules.
Thank you, Vineet. Moving to the next point, we have read that the local branch offices of international nonprofits or think tanks that were incorporated or established in India to distribute funds locally from the foreign parent entity will no longer be able to do so. Naushir, can you please share your views on this?
So it is very clear now that 29th September onwards, grant making or sub-grant making by the intermediaries is history. You can't be doing it. Whatever you could do, you could have last done it on 28th of September. And many people, I think even between starting 20th September when the bill was put in parliament, I think people had become reticent about giving. So will these intermediaries registered in India, either as registered branch offices or liaison offices, and were making grants of monies received from overseas, will they be out of business? Maybe not, because I think the two key functions that they were performing was, one is doing the due diligence initially before the grant was made. They can still do it from here in India. The only difference is that the overseas donor will directly give it to that partner, as opposed to giving it to the intermediary who in turn would make the grant or sub-grant. The other is, once the grant is made by the overseas donor directly to the implementing agency, the second part is monitoring and evaluation, which again the intermediary here can continue to doing. Of course, the overseas donor would have to find ways to ensure how these agencies in India can be funded separately for carrying out the due diligence task, monitoring, evaluation, etc. But one thing is very clear and certain, that the days of granting and sub-granting by intermediaries is over. It's history. Yeah.
Thank you, Naushir. That was very insightful. Dr. Fogler, we would like you to highlight the amendments in relation to the bank account, and why was it declared as SBI Delhi branch specifically, and is there a timeline for opening of the bank account?
Unmute yourself, Manoj. Manoj, you're on mute.
Yeah. Specifically, holding SBI as the sole institution where bank account could be opened, it was quite a surprise, and it needs to be seen whether it is constitutionally feasible, because SBI also is a partly government-owned organization. Even though the majority shares are with government, private shareholders are also holding shares in SBI. So that way, creating a monopolistic position for SBI itself is a issue which at some point of time needs to be addressed, or it will come in some court of law sometime, I believe. But now coming the fact that it is a law and it has not been challenged yet, so it will continue to be a law. So now the law says that one particular branch, New Delhi branch of SBI will hold all the designated bank account, that the funds which flow into India will fall into SBI bank account first, and then they will be distributed. That is the intention. But when we see the rules, it seems that the local generation, that is deemed FCRA, for instance, you sell an asset, so those proceeds also should go back to SBI. So that clarity even is not there in the rules. So it becomes quite a cumbersome process apart from the legality part of it. But now it is a reality and one has to bear. So organizations have to open, all organizations, FC registered organizations have to open a bank account in SBI. SBI already has issued an SOP in that regard, and they can contact their local branches. So it is not necessary that the organization need to go to New Delhi to open the bank account. Maybe these accounts will have multi-city operations. So for all practical purposes, it will be an account, though it will bear a number of SBI Delhi branch, I hope, but it will be treated as a multi-city local branch for respective NGOs. And the government later on has given a clarification. In the act, it has not been provided, but later on the government clarified that there is a window of up to 31st March between which you have to open the SBI bank account, and Till that, your existing bank account will continue. But I should give you some caution. Some organizations managed to open their SBI account. They got their account number, but their account was not operational. And what happened? The SBI account was not working. Their existing account was blocked. So maybe one should hold for some time and let the things settle down. Let SBI itself be clear about the operationality of this bank account. And maybe my advice would be to hold on and not to rush to open the SBI bank account, because in any case, up to 31st March window is there. Maybe a month or so one should wait and let everything be streamlined. Then there is no option but to open that SBI account on or before 31st March 2021.
Thank you, Dr. Fogla. It's always good to know the reasoning behind the opening of the FCRA account in the SBI Delhi branch. Before we start taking audience questions, we have a last question for Vineet and Dr. Fogla. What are the operational barriers that most organizations have seen or foresee, and what could be the possible solutions to those? Vineet, we would like you to go first.
So Pinky, I think we've discussed the operational barriers already, you know, whether they be regranting or they be related to admin costs or renewals. Dr. Fogla was just talking about the complexities of opening the bank accounts and the lack of clarity. The rules are not available yet. We don't know how what we can do in this interim period before March, and we don't know what will happen after that. So I think that those are the challenges. Most of the grantees we work with are kind of in wait and see mode, waiting for clarification because they don't want to step wrong at this stage. There is concern that funds, bank accounts will be blocked, funds will be seized, etc. So I think everybody's kind of waiting for the government to come forth with the rules related to this amendment.
Thank you, Vineet. Dr. Fogla, I would like to hear your perspective as well on the same question.
There are so many operational barriers, so you need another seminar for that. But let me touch upon a few important things. One, some of the operational challenges are already recorded. I must, just for the knowledge of the larger audience, I must tell you that in 2011, 2010, when the FCRA 2010 was amended, it was argued by the government and the standing committee that the government on record, the Home Secretary has recorded in the Parliament that 50% administrative expenditure is necessary because of the diverse character of charitable institutions, research institutions, various kinds of institutions have various kinds of cost which may be perceived as admin expenses even though they are programmatic in nature, and they will face harassment. That is why we need a limit of 50%. This is what is recorded in the Parliament by the FCRA department. So this is the reasoning FCRA department gave in the Parliament in 2010. So the FCRA department itself is aware of the operational challenges which the NGOs may face, and it has been recorded. And I don't think anything has changed between 2010 and 2020 to say that this admin expenses should be, at least we are not aware of any apparent changes which has happened in this sector, the way they work, the way they record their expenses. So that is one challenge which is already there on record and we are discussing. The other is about sub-granting. In 2010, there was a debate where the standing committee headed by Sushma Swaraj argued before the department that the sub-granting should not only be restricted to FC registered organizations. Smaller organizations which are not registered under FCRA should also be allowed to access FC fund, maybe in smaller amounts. And therefore, in the just pre-amended act, there was a provision that not only FC registered organization, non-FC organization could also receive FCRA fund through permission. There is a rule called Rule 24. So this was the other recorded. So now after this act, it will be extremely difficult. It is not only sub-granted organization. Basically, a small organization at the grassroots doesn't have the wherewithal to get FCRA registration, the kind of FCRA registration and the formalities you have. An organization managing 1 lakh rupee a year or 5 lakh rupees a year, it is virtually impossible for that kind of an organization to believe that it will have FCRA registration would work. So that is why the FCRA fund operationally will be used for certain type of activities, certain type of factor, certain type of organizations. It will not be a charity in the normal understanding the way we think charity. So that is one for all times to come, at least till unless these laws are changed. There is a paradigm shift in how FCRA funds will be used in India operationally. There will be only few pockets and few manner in which it could be used, and money percolating to the grassroots will be constrained. It will be extremely difficult. From more imminent and urgent, immediate operational challenges which the organizations are facing, all the existing contractual obligations, the unspent balances, the staff who are there with the grassroots level organizations, the fund which is there with the grassroots level organization, which is not enough to complete the program, the assets which are there with the grassroots level organizations. So now there cannot be any direct or indirect association. Then the new rule which has come, they say that you have to give a declaration that you are not working directly or indirectly or associating with any other NGO. So these are there are myriads of challenges which are coming, and every day me, Nasir, and we are grappling with it. So some of these maybe we can take up if questions come.
Thank you, Dr. Fogla, for sharing your perspectives. Thanks to Vineet as well. We have in fact heard some very interesting viewpoints and facts from the entire panel today. This brings us to the last part of the session. We have some interesting questions already coming in from the audience, but we may not have time to answer all of them. In the interest of time, I would like to start the first question. Let's start with Vineet. Let's start with Noshir. Does remunerations for program managers, training managers, M&E managers, etc. fall under admin cost, which falls under the 20% cap, or is there a way to justify these costs as part of direct cost?
So, as I said, if you look at rule number 5, there is a distinction that you see between management-related expenditure, that is what you would pay to people managing your activities, and people who are directly implementing your programs or projects. So again, if you look at trainers is a form of a teacher. And as you saw, the second proviso of rule number 5 says, such as salaries to doctors of a hospital, such as salaries to teachers of a school. So anyone who is actually providing training, whether it's to women in the villages on skill building, livelihoods, vocational training, remuneration paid to such people, in my opinion, would go as a program expenditure because it is directly for that. M&E again would be in the in the twilight area, whether you can pay somebody who is looking at the monitoring and evaluation as a program expenditure, maybe not. But anyone who is directly implementing that welfare-oriented activity, remuneration, salary, by whatever name you call it, that can be counted as a program expenditure, in my opinion.
Thank you, Noshir. Moving quickly to the next question. This is for you, Vineet. Is there any bigger international donor representing before the central government to address the difficulties faced due to this particular amendment?
So at this stage, not that I'm aware of, not formally anyways. I think no international donor is willing at this stage to put their head up and take the risk. Everybody is consulting with lawyers and trying to figure out what the right way forward is, and potentially having informal conversations and discussion to see what the avenues that might open are.
Thank you, Vineet. I would like to ask Biraj the next question. Can civil society organizations approach court against this act?
Yes, absolutely. Not just civil society organization. Any individual in the country can approach the courts and seek redressal. And I do hope that there will be a very robust challenge, as I said earlier, specifically in the high courts in multiple states, taking up different aspects of the legislation. And eventually there will be a constitutional challenge in the Supreme Court. Now, unfortunately, there have been two problems. One is that the FCRA, even if in its original form, had a manifest arbitrariness. It was unconstitutional in many ways, but it went unchallenged for 44 years. And it speaks very much about the nature and character of our civil society, that we have been willing to live with a bad law for 44 years without mounting a constitutional challenge to it, when it was so blatantly unconstitutional. And despite the fact that in 9 times out of 10, in fact, I would say 10 out of 10, but there may have been one case that the government may have partially won. 9 cases out of 10, whenever FCRA related matters went into arbitration in a court of law on grounds of renewal or on grounds of deregistration or harassment, it is the civil society organization that won. And the government did not appeal this further in most instances because they did not want to set a precedent, because they themselves know that they are on very weak legal grounds. So it's kind of sad that despite having such a rich and vibrant civil society that takes up such a large number of issues on behalf of the marginalized, the dispossessed, and rights-based issues, we are unable to stand up and put up a decent fight when it comes to our rights as civil society organization. We are unable to go that extra mile, to secure the civic space. And I think that is the nature of the beast. It is so punitive, the overall framework, that anyone who has an FCRA is scared that if they spoke up and tried to secure the space, there would be a clampdown and their FCRA would be taken away. So I hope that this leads to finally a strong unionization of NGOs to create a more militant body than we have currently. We have many associations, but we need a more militant minded body which will fight for the rights of organizations and civic space much more aggressively with the governments and with other stakeholders than we have in the past.
Thank you, Biraj. I have my last question for Dr. Fogla. For applications for FCRA or its renewal, it is required to submit Aadhaar cards by office bearers, which is now mandatory. But who are the office bearers? And does it include only board members?
No, because FCRA uses the word key persons, and mostly these words are found in the various forms of FCRA. So one way to look at who are the office bearers and the key person is the definition of key persons under section 13(3) of the Income Tax Act. There we have an inclusive definition of who are the persons. So my advice would be to follow the definition where, so basically under section 13(3) of the Income Tax Act, you will find the founder members, the board members, the manager, secretary, managing trustee. These are all defined as interested person. Otherwise, a key person, the key person which is used in FCRA for all practical purposes, because the Aadhaar card, because the Act says that the government now has a right for asking for Aadhaar card, and they are now asking Aadhaar card related information for the board members, whoever is on the board. Let me inform you that the new rules and the new forms are saying that each change in the board will be subject to government approval. That again is unprecedented and unheard of. How organizations which are subject to various other law can be subject, a board member can be subjected to the approval of FCRA. So basically FCRA right now is confining to board members, board member plus all those members who have, say, decision-making powers. The managing trustee in some organization, you have an CEO who may not be a formal board member, just as an ex officio chair in the board. So those kind of people should be treated as the key functionaries.
Thank you, Dr. Fogla. And with that, we come to a close for today's session. I would like to extend a big vote of thanks to all the panelists for putting forward their viewpoints and possible solutions to some of the apprehensions that the sector is facing at the moment. Thank you, audience, for being so patient and listening in. We look forward to seeing you in our next session with yet another exciting topic. The recording of today's session will be uploaded shortly on our LinkedIn and YouTube page. Have a great day and stay safe.
Thank you.